5 seconds to go. Start. It was lastly submitted that since the decision with regard to a policy decision of the central government would have nationwide repercussions, therefore, only the principal bench would be the suitable bench for deciding the validity of the policy decision. Therefore, it was submitted that the chairman has rightly transferred the OA from the Nainital Circuit Bench to the principal bench in exercise of powers under Section 25 of the Act 1985. In the rejoinder, it was the case on behalf of the original writ petitioner as regards the cause of action that part cause of action has arisen in Uttarakhand as the names of the eligible candidates for the post of Joint Secretary are called from the states. Thus, the names are recommended by the states. The service records of the eligible candidates are with the state and the service records are forwarded by the state. Moreover, as the decision to appoint the joint secretaries on contractual basis adversely affects his right of consideration for the post of joint secretary, hence the impact of the policy decision deprives his right in the state of Uttarakhand and therefore a part of cause of action has arisen in the state of Uttarakhand and therefore the Nainital Circuit Bench has jurisdiction to hear the OA. That thereafter, after considering the relevant provisions of the Act 1985 and following the decision of this court in the case of L. Chandra Kumar versus Union of India 1997 3 SCC 261, the High Court has allowed the writ petition and has set aside the order dated 4th December 2020 passed by the Chairman Central Administrative Tribunal, New Delhi, by observing that there is no requirement of law that a policy decision must necessarily be challenged before the principal bench and that there is no provision under the Act 1985 that a challenge to a policy decision can be heard only by the principal bench. Feeling aggrieved with the impugned judgment and order passed by the High Court, Union of India has preferred the present appeal. Shri Tushar Mehta, learned Solicitor General, appearing on behalf of the Union of India, has vehemently submitted that as such the High Court of Uttarakhand has erred in entertaining the writ petition. It is submitted that as such no cause of action has arisen within the territory of Uttarakhand High Court. The Uttarakhand High Court lacked the territorial jurisdiction to entertain the writ petition against the order passed by the Chairman Central Administrative Tribunal Principal Bench, New Delhi. Heavy reliance is placed on the decision of this court in the case of L. Chandra Kumar Supra as well as on the decision of this court in the case of Union of India versus Alapan Bandhopadhyay 2022 3 SCC 133. In the case of Alapan Bandhopadhyay Supra, after considering and following the decision of this court, in the case of L. Chandra Kumar Supra, it is specifically observed and held that all decisions of tribunals created under Article 323A and Article 323B of the Constitution will be subject to the scrutiny before a division bench of the High Court within whose jurisdiction the concerned tribunal falls. It is submitted that before this court an identification question arises. That before this court in the case of Alapan Bandhopadhyay Supra, the High Court at Calcutta set aside the order passed by the principal bench New Delhi transferring the OA and its files from the Calcutta bench to the principal bench New Delhi. that it is observed and held by this court that the Calcutta High Court lacked territorial jurisdiction. Shri Tushar Mehta, learned Solicitor General, heavily relied upon paragraphs 15 to 17. Stop.